So we're going to get started. We have a plan for this afternoon, and I'm going to unfold it just to give you a sense of how we're hoping you will help us. We are going to start hearing from our two panelists, who I'll introduce in a few moments, and they're going to try to create for us something of a framework for the discussion that we'll have this afternoon, as well a little bit of a vocabulary. So they're going to give us some ideas and some terms that we may be able to work with in our groups. We will then break after we've heard something from them, and we are going to give you half an hour to discuss amongst yourselves the scenarios. Now, note that each table has a specific scenario that we're asking you to focus on, and that is flagged on the table assignment sheets and also on the scenarios themselves. So if you look in either place, it should tell you which is your scenario. So a good first step for each table will be to decide what your scenario is, so that you're all talking about the same thing. Below the scenario, there are some questions, and that is the framework that we're hoping that you'll use for your discussion. We don't mean to constrain you to that, and feel free to discuss other things. But the importance of the framework is that will allow us to come from these small groups back into a larger group and still be able to understand each other. Because while tables are talking about different scenarios, all of you are ultimately asking something of the same questions. So when we come back from the small group work, each table is going to report in. And that will allow us to compare across the scenarios and issues that the fact patterns present some of the same questions and challenges about what the core values of our regulatory system are or should be, how they may be engaged by the kinds of innovations that are being discussed today, and where we might try to find a path in terms of striking the balance. So we will have each table report in turn once we reconvene to the larger group. Your facilitators are going to help us do that, so they'll hopefully have organized themselves to have something to say on your behalf quite briefly. And then we will have a final panel, which will include our panelists, but also will allow us to be rejoined by Malcolm Mercer and Susan McGrath, who, as you've heard, are the working group co-chairs. And so they'll be up here to hear from you and to think about what the table's feedback tells them about the project that lies ahead. So before we turn it over to you, as I said, we have two panelists, and we're very excited to have the chance to work on this afternoon session with two legal scholars and ethicists who I think really typify the kind of exciting work which is now happening in our Canadian law schools. They are both involved in some of the work that tries to create new structures for the teaching of legal ethics and also new ways of thinking about legal regulation. Amy Salzin has recently joined the Faculty of Law at the University of Ottawa, a very prestigious place. She's down the hall from me. And she is at the same time, though, much more prestigiously completing her doctorate at Yale, where she is doing a comparative study of legal regulation in England, the US, and Canada. So she really knows everything about everything that we've talked about today. Amy's recent work, though, focuses on ethical infrastructure. And so she's going to discuss with us this afternoon how that kind of framework might be helpful in framing the present discourse. Noel Semple is also a legal ethics scholar, and he's currently holding a SSHRC postdoctoral research fellowship at the University of Toronto Faculty Law, where he's working with the Center for the Legal Profession. And he, too, is working on legal ethics and legal regulation and looking particularly at the interplay with access to justice, which we've already realized today, I think, should be a part of our discourse. So together, Amy and Noel are going to be our guides and our facilitators, and we're going to start from hearing a little bit from Amy about the vocabulary, and then Noel will move on to talk a little bit about ABS.
Great, thanks Pam, and thanks for having me here today. As Pam said, Noel and I are just going to talk for a few moments, probably about half an hour, providing some introductory comments to hopefully provide framework that'll help us when we break out into group discussions. When ABS is talked about, as it has been in this jurisdiction and others, a number of core values, core ethical values often get raised. In particular, concerns about competency, client confidentiality, and conflicts of duties are repeatedly raised in the conversations. No doubt many of you are very familiar with these concepts as lawyers or academics. You're familiar with the rules of civil procedure and the case law. But today, just to kind of focus our minds together and give everybody a common starting point, I'm going to spend a few moments introducing these concepts and provide a bit of informal background that will be helpful, hopefully, when we talk about the scenarios. Certainly more can be said than I'll say in 10 minutes, and the values I talk about, I should emphasize, aren't meant to be any sort of master list or definitive list of all the ethical issues raised by the introduction of alternative business structures. Again, the aim is just to have a little bit of upfront discussion of some of the frequently discussed values in order that we can have some grounding for our conversation. Noel will be speaking after me about how some of the ethical issues that I talk about are raised in alternative business structure discussions. Right now, I'm just going to focus quite simply on introducing the concepts. Again, as Pam said, providing us with some common vocabulary. In discussions about ABS, we often hear arguments about the impact of new entities or new arrangements on the quality of service for clients. Translating this to a discussion about legal ethics, we can understand these arguments in terms of lawyer competence. And certainly we see a few points on the slide. The issue of lawyer competence is multifaceted. We know that a provider of legal services needs to have appropriate knowledge and skills. Also, of course, the provider needs to have the capacity to effectively respond to a client's situation. Some of the ABS discussion focuses on enhancing that capacity for sure. And more, as should be evident from some of the conversations earlier, we're also understanding competence to relate to technical competence and the ability of legal service providers to harness technology in order to effectively serve their clients. In terms of why we talk about lawyer competence, certainly lawyer competence is a good in and of itself. It's fairly self-evident that clients need competent legal services. No one wants an incompetent lawyer. But we can also understand, building off some of the conversations this morning, that the motivation to regulate competence is connected to what we understand to be certain imperfections in the market for legal services. And as Professor Gillian Hadfield's pointed out quite prominently in her work, there's a number of imperfections in the market of legal services. The presence of things like information asymmetry make it important that clients can be assured that they have an adequate level of service. Professor Flood talked this morning about legal services being a credence good, the same type of idea. The main point is clients might not be in a position to themselves effectively evaluate the quality of their legal services. So there's an idea that we need some type of regulation in place to make sure that they can trust that they're receiving adequate services. Moving on to the second core value I'm going to be talking about, another ethical value that often gets raised in discussions about ABS is client confidentiality. And it's certainly been something we learned in first year law school, a core tenet of our legal system that the effective delivery of legal services requires that clients be assured that all information about their business or about their affairs they transmit to lawyers will be kept confidential except in extraordinary circumstances. And the rationale behind this, we see it in case law, we see it in legal ethics textbooks, is quite simply if clients don't trust that their information will be kept confidential, they may be reluctant to give their legal service providers information that might be relevant to their case. They may even be reluctant to approach a lawyer in the first place. And so the rationale says that therefore this information needs to be under strict confidentiality measures. In the ABS context, and perhaps Noel will be talking about this a bit, the fact that lawyers are under a much more rigorous, higher standard of client confidentiality than other professions. Certainly, we've had to recently deal with the issue of paralegals, and now we know they enjoy similar types of confidentiality. Accountants, maybe not so. And so the idea of bringing these people into business structures creates concerns. As a final point, it's probably important to mention, even though we talk about confidentiality and solicitor-client privilege, often as interchangeable terms, and that's normally okay. It is important to understand they actually are distinct concepts, with confidentiality being a broader term that applies to all information obtained in the context of a retainer. And as we know, solicitor-client privilege relates to information delivered by a client for the purpose of receiving legal advice. This distinction is a little bit important when we think about the fact that, for the most part, confidentiality obligations reside in professional codes of conduct, certainly common law too. But the idea of privilege is really a court-governed, court-created ethical obligation. And certainly when we think about ABS and regulatory responses, we need to understand that even though we proudly proclaim to be self-regulating, we certainly have courts that are very active in governing different ethical aspects of the lawyer's conduct. So certainly a regulator could choose to go down one path, but there's still the court system out there that will choose to make their own decisions. So just to appreciate that there's a variety of regulators in the field. The third issue, conflicts of duty. The issue of conflicts is often raised when people talk about introducing new entities, new individuals, either as investors or partners into legal services. Concerns about conflicts of duties. And one way to think about these conflicts, one way to organize them, is to think about them flowing into two different categories. First, client commitment. This is probably what we most obviously think about when we think about conflicts of interest. The idea that a lawyer owes a duty of loyalty to their client, a duty to avoid conflicting interests. But we can also think about a second set of potential conflicts. Conflicts relating to the lawyer's duty, obligation to have what's called in the literature fidelity to the law. And in simpler terms, this simply means a lawyer's duties as officers to the court, lawyer's duty is to enhance the effective administration of justice. So again, in terms of client commitment, we know the Supreme Court's told us lawyers have a duty of loyalty, a duty to avoid conflicting interests. And we know now also that this duty is looked at as protecting or preventing two types of prejudice. First, a concern about the misuse of confidential information, and also it's looked at targeting and preventing failures of a lawyer or legal service provider to resolutely represent their client because they have either their own interests, an interest of another client, or a third party competing with their duties to the client. And one particular concern that's raised in the ABS context is that a lawyer's duty of candor to the client may be compromised when there's a competing interest. And this links to one of the ideas discussed earlier, the idea that the client really relies on the lawyer to be honest, candid. They rely on the advice from legal service providers in order to make decisions. We also understand the issue of candor being related and important in relation to a lawyer's obligations to courts and tribunals. In our adversary system, like many others, we've embraced the idea that the effective administration of justice requires that lawyers treat tribunals with candor, fairness, courtesy, and respect, and that the adversary system relies heavily on legal advocates to not only vigorously represent their clients, but also candidly present evidence and arguments before tribunals. And beyond the idea of candor, we can think of a number of obligations that a lawyer owes to the courts and to the justice system, whether it be a duty not to pursue frivolous claims and a duty to report misconduct too. And so we can think about how outside interests, other involved in the law firm may compromise those duties. And in the context of ABS, these concerns are often raised by using the term lawyer independence. Certainly a term that has a variety of meanings, sometimes very political meanings. But in this context, we could think about the idea of lawyers being required to be free from external direction or external pressure that affects their ability to act in the best interest of clients and to ensure the effective administration of justice. So that's first year legal ethics in 5 minutes, everybody. Everybody's still awake. I'll be turning it over to Noel soon, who will kind of be getting into the more exciting matter about how some of these ethical values are engaged with alternative business structures. Before doing so, I just want to mention and reiterate, of course, that the three values, concerns about competence, confidentiality, and conflicts of interest certainly aren't a closed list, like I said at the beginning. Access to justice is very much an issue at play, we've heard today. And we might also want to think a bit more broadly and think about the concept of professionalism and ethics as encompassing things like diversity in the profession, also well-being of legal professionals and lawyers, and think about how alternative business structures may enhance or inhibit the realization of those goals. And again, a number of other values may be at play, and we've given you some in our quick snapshot today, but certainly when we break out into the group discussion, feel free to be creative. I think with that, I'll turn it over to Noel.
So Amy said that my presentation is going to be exciting, which I can't guarantee. But what I am going to try to do is give you a few ideas about the threats and opportunities to legal professionalism which may be created by alternative business structures. And that's also my outline. I'm going to start with the threats and then move on to the opportunities. So the basic idea in the theory of legal professionalism, the basic reason why some legal ethicists oppose alternative business structures is that it's said to be a threat and something which undermines the relationship between legal professionals and their clients. So in the traditional practice structure, solo practice or a partnership of lawyers, we have this idea that there's a relationship of trust between the client and the legal professional, which is built, as Amy said, upon the competence of the legal professional and confidentiality and those other core values. So the idea is that it has to be a relationship of trust. It can't be just a market transaction because of the information asymmetry, because of the fact that clients are not in a position to judge their own need for legal services, nor are they in a position to evaluate the quality of legal services that they have received or how much they're being asked to pay for those legal services, at least in the case of unsophisticated clients. So the trust which the client feels in this relationship is engendered by the fact that the legal professional is responsible exclusively to the client. They're not distracted in those traditional practice structures. They're not distracted by any other duties or any other masters. Okay, so that's the traditional practice structure. Now, what happens when we introduce alternative business structures? The idea is that introducing people other than the client and the legal professional to this relationship undermines those core values and undermines the trust. So first of all, ABS undermines that relationship through conflicting interests. If a venture capital firm or a private equity firm invests in a law firm, that firm will be only one within a portfolio of investments held by the investor. So what if one of the investor's other investments is a business which is the adversary of the law firm's client in litigation? Will the venture capitalist then tell the law firm in which she's invested to soft pedal their approach to that litigation, right? So that's an example of a conflict which is raised sometimes. Then we have the threat to client confidentiality. Investors typically demand information about their investments. In the context of a publicly traded corporation, securities law gives investors the right to have that information. So a non-lawyer investing in a law firm could very easily feel entitled to demand information about that firm's files, about that firm's clients, which of course would undermine client confidentiality. A non-lawyer employer of lawyers would have a similar incentive and a similar sense of entitlement to demand that information. The second way that ABS is said to undermine this relationship is through the demand for profit. The idea here is that outsiders will undermine the relationship by insisting that lawyers produce more revenues with lower expenses. They'll insist on corner cutting, which undermines the competence value, which Amy discussed. They will insist on firms cherry-picking the most lucrative cases and abandoning the less lucrative or more complex cases. They will insist on lawyers abandoning their pro bono obligations to provide legal services to those who can't pay for them. So the theory runs. So the obvious objection to this is, well, what about the profit motive of the legal professionals themselves? Don't they experience the same temptations to cut corners, to cherry pick, and so forth? Well, according to the traditional theory of legal professionalism, the answer is no. Because we have this idea of the business-profession dichotomy. The theory here is that true professionals, including legal professionals, are altruistic in a way that most people are not. Business people are motivated by money. Lawyers don't care about money. Or lawyers may care a little bit about money, but they don't care as much as other people do, right? Lawyers only require a modicum, sort of a modest living. And once they've reached that point, they're no longer avaricious. Their commercialism, as we say, is balanced, unlike the commercialism of other people. So lawyers' motivations, which are not money, include the motivation to provide competent service, the dedication to providing high-quality work at whatever cost, the motivation, the service orientation idea, that professionals are moved by the need to provide services to people who don't have them, and that's why they engage in pro bono service and so on. They're motivated by the ideal of the rule of law and by contributing to the administration of justice. So non-lawyers, non-legal professionals don't care about any of those things, and if we let them meddle in law firms, they are going to undermine the dedication of legal professionals to those things. So runs the theory. Legal professionals have this altruism, but their altruism is vulnerable to temptation. And that temptation comes from ABS and from non-professionals. Bruce Green compares this idea of professionalism to the biblical story of Samson and Delilah. Samson was the mightiest warrior of the Israelites, but he had this weakness, he had this vulnerability. If his hair were to be cut, he would lose his superhuman strength. So the Philistines sent Delilah to tempt him, get him to let his guard down. His hair was shorn and he was captured, and the Israelites were undermined, right? So the idea in this theory of legal professionalism is that legal professionals are like Samson. We're naturally altruistic, but if you expose us too much to commercial influences, to business people, then that altruism, that professionalism will be undermined, will be tempted and defeated. Therefore, regulation is there to protect us from those influences. So to sum up the argument against ABS, two is company, right? Two is company if those two are the legal professional and the client. Three is a crowd. Letting a business person, letting an investor, letting a non-lawyer employer into that relationship ruins it and leads to the downfall of legal professionalism. Okay, so that's the theory of the threats. Now on to the theory of the opportunities. So the idea here is that alternative business structures are actually an opportunity to respond to the biggest real challenges to legal professionalism, especially in the individual client hemisphere, right? Family law, criminal law, immigration law, all those types of law which are practiced on behalf of individuals as opposed to corporations or institutions. And the idea is that investment from non-lawyers and collaboration with non-lawyers can make law firms larger and make them more innovative, which in turn equips them to better honor the core values of legal professionalism, which Amy discussed. So the idea is that the real threat to legal professionalism, the real threats to ethical conduct among legal professionals is not commercialism or the profit motive. The real threat comes from things like practitioner isolation, financial insecurity, and lack of innovation. So practitioner isolation. In the small firms and solo practices which dominate in the individual client hemisphere, we have people who experience enormous stress that comes from trying to run a business while at the same time practicing law. We have legal professionals who have to take responsibility for very demanding clients and very complex legal situations in an environment where they often have little or no support. And some people say that this practitioner isolation is actually the root cause of most of the actual ethical problems that regulators experience, right? So the idea here is that the Law Society, I mean, if you look at the actual files that come through the door of the Law Society, the actual complaints, they're very seldom about, legal professionals being evil or being excessively avaricious. They're about people who they just can't cope, right? They tend to be small firm solo practitioners, and the demands of maintaining a business while practicing law just become overwhelming. And alternative business structures, it's said, could help by bringing in new investment and allowing legal professionals who serve that individual client hemisphere to work in larger and better capitalized firms. If ABS comes in and we have Loblaws Law or Walmart Law, and you're a legal professional and you work for Walmart Law, providing family law services or whatever, all of a sudden you can actually take a vacation and someone's going to handle your files, right? All of a sudden, someone else is handling the marketing. Someone else is handling the HR. Someone else is handling the tax and the regulatory filings. So you can all of a sudden actually be a lawyer, actually focus on practicing law. And the idea is that that lets you focus on being a better legal professional. And it, sort of gives effect to your natural desire to be a good lawyer and reduces dramatically the likelihood that you're going to end up in that stressed position where people end up, which leads to the complaints and the lawsuits and all the other actual failures of legal professionalism. Financial insecurity of small firms and solo practitioners. They have great difficulty accessing the capital which they need to run a law firm, let alone accessing the kind of capital which you would need to run a sort of technology-enabled access to justice-oriented firm. They tend to have high dependence on a narrow practice area or a narrow geographical area. And this financial insecurity, again, leads to some of the temptations which we see playing out in regulatory problems and in failures of legal professionalism. Alternative business structures, as we heard in the last panel, means economies of scale. It means economies of scope. It means letting legal professionals work in businesses which have a broader financial base, which are better able to sort of mitigate the stresses of economic cycles and of changes in the law because they can draw on a larger geographical market and serve more practice areas at once. And Professors Iacobucci and Trabilko really developed that point. The third thing that's there is lack of innovation, right? So clients want flat fees. Clients want quick, if not instantaneous, communication from their legal professionals. Clients want reputable consumer brands. And some clients want more control over their own files. It's very difficult for a small firm or a solo practitioner to provide those things because they depend so much on economies of scale and scope. Alternative business structures allows investment and allows collaboration with non-legal professionals, which in turn enables them to provide that innovation that clients are increasingly demanding. So in sum, these things are the real problems with legal professionalism, and ABS can actually lighten the load. ABS responds to them, and in that way, it's harmonious with legal professionalism. So runs the argument. So we talked earlier about the business-profession dichotomy, which is a sort of a key tenet of the traditional approach to legal ethics. Well, for people who support ABS, they actually say that we have a business-profession harmony. Either lawyers are not actually, more altruistic than other people, or if lawyers are more altruistic than other people, then that altruism is not so tentative, is not so vulnerable that it will be overwhelmed by the presence of external investors. And moreover, making law practice more businesslike can actually improve it, actually makes it more professional. And if so, then allowing ABS is actually the best thing that we can do for our core values. It's actually the best thing we can do to enhance the state of legal professionalism in Ontario today. So in conclusion, we've got a series of threats and we've got a series of opportunities. Whether you see ABS as a threat to legal professionalism or as a boon to legal professionalism, to some extent depends on your philosophic starting point. But it's also a tension which I think we can respond to creatively as regulators in looking for a route forward. I'm looking forward to the conversation about that. Thank you.
We're a bit of a tag team here today. I know we're kind of up against the time, but I'm going to just talk briefly about the concept of entity regulation, ethical infrastructure. A lot was already said today, so I'll try not to rehash too much ground. I think one message that we heard today from a number of the presenters is that one of the interesting things that has happened with the introduction of alternative business structures in other jurisdictions has really opened up the way to thinking about a new model of lawyer regulation that moves away from leaning so heavily on an individual after-the-fact complaint-based model and looks to complement that with looking at regulating institutions proactively through an educational-focused system. We've heard Australia, in particular, being in the state of New South Wales, really being a model that people are quite excited about. Essentially what happened there, to repeat and to remind you of what some of the other speakers have talked about, with the introduction of incorporated legal practices, a form of ABS, regulators were prompted to start proactively engaging with law firms to promote the idea of effective ethical infrastructure. And the term ethical infrastructure now is kind of becoming somewhat of a buzzword. It's not a new word. It originated with a professor from the University of Arizona a number of years ago. But in terms of what it means, it's really just a fancy way of talking about all the policies, procedures, structures that an institution, an organization has in place to encourage and promote lawyers fulfilling their ethical duties. And so to be kind of quite simple about it, we can think of things like conflict check systems. We can think of things like template retainer letters, billing protocols. Those would all be examples of systems, policies, or procedures in place at a law firm that aims to ensure that the individuals in that law firm comply with their ethical duties. And specifically what the regulators did in New South Wales is they introduced a procedure by way which incorporated legal practices would self-evaluate whether or not they had appropriate management systems in relation to 10 areas of ethical concern. And rather than dictate any specific practices, they simply required firms to evaluate their processes and report to the regulator and receive feedback and response. And the statistic's been quoted several times today because it's quite remarkable. What they've seen is that since implementing this system, firms that have used the system have on average 1/3 the complaint rate in the same firms before using this system. And another interesting aspect of this is it didn't really matter how, so in the system, firms check off whether or not they're compliant in this area, partially compliant or not compliant. And the study found it didn't really matter how firms ranked themselves in terms of whether or not the complaint rates went down. It really mattered that law firms started to look internally at their management systems, started to self-reflect. And that is what the authors of the study felt really made a difference. Moving beyond this exciting information about complaint rates, I also think the idea of talking about proactive institutional level regulation, and certainly you can do it the way Australia has with this self-assessment process, but we can look to England and Wales with their outcome-focused regulation, also the requirement that firms have compliance officers that are essentially in charge of looking at the institution, ensuring that it has appropriate structures in place. But one of the interesting things that this proactive regulation at the institutional level opens up, I think, is the ability to look beyond some of the black and white offenses that we often focus on. We focus on regulating the individuals. So things like trust account fraud, things like egregious client service problems. We certainly always need systems to address those. But there's more systemic issues. We know we have a few people from Law Pro today, but one of the biggest areas of concerns is client communication. Biggest area of malpractice complaints. I also think probably a high rate of complaints to the Law Society. And it may be that a lot of client communication issues aren't really well suited to sanctioning individuals in a disciplinary hearing. It may be that the law firm itself at an institutional level doesn't have proper procedures in place. And so having a system that looks at institutional level ethical practices can really start to target those types of systemic issues. We can also think about some of the broader ethical issues that I talked about, introduced, access to justice, diversity, employee wellness. Again, these things may not be suited to a complaint system where we hold individuals to account in disciplinary hearings, but they can be something that a regulator looks at when it starts looking at what policies, procedures, structures a firm has in place, and encouraging the firm to look at making their own, it's not a one-size-fit model, but making their own policies, procedures that really help to enhance the realizations of these ethical values. In terms of how this might play out, just wanted to note a recent Canadian example. This year I worked with the CBA Ethics and Professional Responsibility Committee, and the chair of that committee is here, Malcolm Mercer, to create what might be a possible ethical self-evaluation tool for firms to look at these types of things. Obviously, it's not a regulator taking this on, and it's not necessarily in reaction to ABS, but this shows how this could actually play out on the ground. Just kind of give that whirlwind tour of entity regulation, just to keep in your minds that the potential regulatory responses to ABS doesn't necessarily mean, changing our rules of confidentiality and the rules of civil procedure, though it certainly can mean that, but can also mean an opportunity to really think about the orientation of our regulation and look for opportunities there. And with that, I think we'll turn it over to the groups. Or Pam, perhaps.
Thank you so much to both Amy and Noel. I think they deserve a hand. So it is now time to turn it over to you, and our hope is that you will, working with that framework they've created for you in terms of the kinds of ethical values that we hope will form part of your conversation, some of the pros and cons as they've been set in the debate to date, and the idea of being creative and looking forward at new approaches and new mindsets, that you'll turn to those particular scenarios and begin that conversation. At 2:45, we go to break. So we'd like you to stay in your small groups until the coffee is returned to the table at 2:45. Then you get a break and a breather. We'd like you to be back and ready to talk in the larger group by 3 o'clock.